Okay, Tracy, can you hear me?
I can hear you.
All righty. Okay, we'll go on the record here with proceeding number 24F-0430CP, Lysenko versus 303 Party Bus LLC and 303 Concert Rides LLC. Today's the 13th of February 2025, approximately 10 a.m. This proceeding comes on for a pre-hearing conference pursuant to decision R25-0029-I. I'm Administrative Law Judge Robert Garvey. I will start with appearances and I will start with the complainant.
Hello, Your Honor. Yes, my name is Roman Lysenko. I represent myself.
All right. Good morning, sir.
Good morning, Your Honor. Attorney John Sean Jennings with the law firm Ireland Stapleton. I represent the respondent in this case. Nick Casillas is also here and he's on camera. He's the owner of the responding companies.
Good morning, gentlemen. I will, before I get started on this, I will say that I'll tell you what, I'm not going to do that. Normally what I was going to do is going to set up a hearing for this. But I guess I want to ask both parties here, whether you think a hearing is even necessary here. Mr. Lysenko, do you think a hearing is necessary?
So, according to responses, most likely hearing may not be necessary because some of the violations been admitted already, Karen. But I will need to honestly, if I can just go back for maybe today and just read through the responses once again, just so we can just reply if we need the.
Well, we're either going to set a hearing today, Mr. Lysenko, or we're not. I just was curious, and you are quite correct in when I read, Mr. Jennings, when I read the response or the answer that you filed, it appeared to me that there's not any factual discrepancies here that I can see. And so I don't know. I mean, is doing through. Let me again. I'll let you go first before I start spewing out my ideas.
Got it. And just another one. We always can file the motion for summary judgment right before we can.
That's one of the options. That's one of the options that we have here. Mr. Jennings, what do you think?
We just want to. Yep. Go ahead, Mr. James, sir.
Thank you, Your Honor. Yes, as you read the pleadings, we did. I'm looking at paragraph 11 of our response. We admitted providing a limited number of rides. We're in the process of gathering the information. I believe it's about somewhere between two, three, potentially 4 rides that we're ultimately talking about here. And so that was the reason for responding the way we did. As we did note in the response, those rides have stopped. We are taking this matter very seriously. I think in the nature of a hearing, we would want to present, we've certainly heard Mr. Lysenko's side of the story. We do feel like there are mitigating factors, and we could put on testimony as to, why the companies have been doing what they've been doing. And we noted that there is a pending application proceeding, which, hasn't been decided yet, but the issue there is extension of territory, and it does cover sort of the disputed location that Mr. Lysenko has raised. So, that would be our response, Your Honor. Certainly won't be revealing settlement communications, but we did speak with Mr. Lysenko about an efficient way to resolve this matter, and knowing that there is another application proceeding pending, we're certainly up for an efficient resolution of this case. And as I mentioned, I think what we would be doing is in the nature of testimony is explaining our side of the story and presenting information about mitigation and responding to some of the contentions that Mr. Lysenko put forward.
Okay. And that's kind of what I thought. I mean, one of the reasons, your motion to dismiss, you read my response on that. I could have dismissed it and we could have restarted this again, and it would have cost more money for everyone all along the way here. And I don't think that's a really good resolution. I also don't believe that we need a hearing on any factual disputes, since there aren't any. The only question is whether you think you can show the mitigation through a written response or whether you want to do it in person. And I don't want to limit you on that. So I mean, I will go with whichever way you want to go on that. And again, I look at it somewhat as a financial question for you too. Obviously, it costs more money to put out a day-long hearing as it does probably to write up a response. I mean, Mr. Lysenko could write basically a summary judgment motion and stating what he believes the penalties are, what sort of what should be paid in that as far as damages or not. But I'm getting that from Mr. Jennings. You'd prefer to have a hearing just basically on what the penalty will be? Mitigation or aggravation, however you want to look at it, hearing.
Your Honor, if Mr. Lysenko agrees that basically, as I mentioned, we didn't have the specific number of rides, but that's the primary issue, and I think we'd be happy to handle this in writing. I did speak with Mr. Lysenko about a procedural schedule, and we were actually looking a couple months out. So that may be a way to resolve this matter more quickly by doing it in writing in the near future over the next several weeks. So that would be one caveat. If we were setting a hearing, we were looking potentially into the month of May or June.
Okay, Mr. Lysenko, okay. I'll let you talk to Mr. Jennings for a while. I'll let you say what you think.
Yes, Your Honor. And another concern that I have is that we need to use the hearing, actually the evidentiary hearing, just to show scale of violation, just to show and discuss that. Then we need to show there is another company, right? So the one company, 303, did admit it, been transporting, but there is another company that Mr. Casillas owns and been violating the law as well. So there is two companies up there, and we need to discuss that violation, which was kind of supposed to be operating as a broker and transferring people to 303 party bus, but it's actually that's the 303 concert rights. So that's the second company. So, but it was doing it in proper way. So it was another unlicensed motor carrier company. So that's another thing that the question that needs to be raised, and that is not covered in the responses. And that's what we need to take through the hearing and testimonies and stuff like that.
Okay, hey, let me ask you one thing. You said the scale of the violation. What do you mean by scale?
So the 303 party has been providing shuttle services for a couple of years. So for some reason, Mr. Jennings only saying and covering last 3 rides or 4 rides after the denial of the previous application. But in that previous application, it was discovered that the 303 party has been transporting passengers, unaffiliated, unrelated passengers on regular routes for a couple of years already. So it's been discovered in the previous application for extension. Then Mr. Casillas did not stop at the decision when the application was even denied. He did not stop, and he continued going with violations, which shows willfully ongoing violation. That's why we're asking for a revocation of the permit and the revocation of the certificate, because Mr. Casillas has been breaking the law ongoing for the last couple of years. So that's what the concern is for the hearing. So it's not the so we want to show the scale of violation, and I want to ask for refund to all those customers. Those two companies been operating as a public carrier and public utility without the license. So
well, hang on, I gotta stop you on that one right there. I don't think you have standing to ask for refund for those customers. So I would put that way. You might want to argue on that one, but I don't see that would be the case. Are these claims that you're making here, are these in your complaint?
Yes.
Okay. As far as I could see, Mr. Jennings, it looked to me that you admitted to. It looked like the answer admitted to everything that's in the complaint. There's, I think, about 4 paragraphs of facts that are alleged, and I believe they were admitted to. So I guess I'm kind of lost on that. That's why I didn't think there was anything more that we needed to figure out that way.
There is an area to address, Your Honor. There are, there's 303, and I get the names confused, but those are two companies that are related, that are owned by Mr. Casillas. And I believe that, Mr. Lysenko, some of his claims go to, some of the claims go to one or the other entity.
Okay.
We're going to show that they're related entities. They're all providing service with the same vehicles. And so, our case is that it's going to be, it's not a major issue. There is one certificated transportation provider here. But we have admitted the facts with regard to additional rides provided by 303 Party Bus. And so if Mr. Lysenko, isn't going to be, satisfied with that and wants to pursue, claims against this entity, which, as I mentioned, they're both owned by Mr. Casillas. They're two versions of a website essentially that run under the same vehicles. Then I think that is probably an outstanding issue. And I guess, just to respond as well, we don't believe that revocation of a permit, is the appropriate remedy. And so we're happy to respond to that in writing or at a hearing. But if that's what Mr. Lysenko is asking for, then, then certainly we would want to put on our evidence as to why we don't think that's appropriate here.
Okay. All right. Well, I think we'll set this for some sort of hearing now. Mr. Lysenko, how many witnesses do you think you'd have?
I would say maybe 2 or 3. So myself and a couple, maybe subpoena hustle witnesses. So I would propose only 1 day and fully remote if it's possible.
Yeah, no, that's well, sometimes I don't see some proceedings we have pre-file testimony. I don't. Most complaint cases I do not. So, Mr. Jennings, how many witnesses do you think you would have? I
think just 2 to 3 witnesses, Your Honor, and it sounds like they may be some of the same people. Okay. I'll ask Mr. Lysenko, because there's a small number of people involved in here, the owners of the companies, and so some of the witnesses may be the same on both sides. Okay. Well, I'll tell you what, let's set a procedural schedule up then. Well, and Mr. Jennings, you said you guys talked about one, is that correct? You have one you want to propose? Yeah, just in broad strokes, Your Honor. We were looking at something in the month of June, potentially. In June? Okay. Well, I'm going to have filings done, so I'm going to have Mr. Lysenko. If you could file your exhibits and a witness list, if you're looking in June, I'll give you a lot of time. We'll say about March 21st. And Mr. Jennings, we'll say April 18th for you. And it'll be all the way in June. That's way out there. How about June 5th for a hearing?
Your Honor, I apologize. Can we? Because the new news about proceeding without the hearing actually did change my plan for this pre-hearing. So honestly, I was it did surprise me. So is it possible? I apologize. I know you just scheduled the pre-hearing schedule. Can we just go and can I just agree on Mr. Jennings to resolve that without the actual evidentiary hearing? So if we can do that and just take whatever is already in the proceeding and kind of proceed with that. So
you don't want an evidentiary hearing?
No, not anymore. I apologize. As I took a couple minutes to think about it. So I don't want to add too much to that. So I don't want to waste PUC times. I know you guys overloaded, and Mr. Jennings' time, and then Mr. Casillas' money. So
Okay, all right, I tell you what we're gonna do then. Let me tell you what we're gonna do. Let's set a date for motion for summary judgment. Okay, and so Mr. Lysenko, we'll do the same one. I'll give you until March 21st to file a motion for summary judgment. All right, then Mr. Jennings, you can have, I'll give you till the 18th. I'll give you the same dates to respond to that. I'll give you a whole month to respond to that motion for summary judgment. Then I'll rule on it and we'll see what we got. And if we still need a hearing after that, we'll do that. If not, we'll be all done. How's that work?
that's wonderful.
Mr. Jennings, what do you think?
That works, Your Honor. Thank you.
Yeah, I save money for people if we can do that. And I don't think there's a lot of factual disputes. I think it just comes down to what if any penalties are going to be assessed here. So I think that works. So okay, like I said, motion for summary judgment due 3/21 by the end of business, and response is going to be due 4/18. I don't want to reply on it. If there's something that you see that you think, take a look at Mr. Lysenko, I know you are familiar with our rules, and so you can take a look and see what we have to do if there's a reply. But generally, we don't take replies after that, unless there's certain criteria that are met. So, okay, why don't we do that? And if for some reason the case is still living after that, then we'll set it for something more. Okay, that work for you, Mr. Lysenko?
Yes, it does, Your Honor.
Okay, Mr. Jennings, what do you think?
Yes, Your Honor. Thank you.
Okay. All right, if there is nothing else, we'll be in adjournment. Last call, last chance, Mr. Lysenko, anything?
No, Your Honor, thank you so much. You did cover it all.
Okay, Mr. Jennings, anything?
No, thank you.
All right. Okay, we will be in adjournment. Everyone have a good weekend, and I look forward to reading what you got. Thank you.
Thank you. Have a good day.